to anyone just joining us. Welcome to the Understanding Recreational Immunity webinar in Oregon, hosted by the Oregon Trails Coalition. We have received a lot of interest in this issue from our coalition partners, and we are really grateful to today's panelists for joining us today to break down just the heart of what recreational immunity means, how recent court cases have affected Oregon's laws, how agencies and other land managers and other folks who care about recreational access are responding. So I'm gonna go ahead and just very briefly introduce our other panelists today and then hand it over. So today, we have Kirk Mylander, General Counsel for City County Insurance Services, joining us. We have Chris Havel with the Oregon Parks and Recreation Department, and MG Devereux with Metro Parks and Nature, and Erik Kancler with Erik Kancler Consulting. And we're really grateful to have you all here. And I'm going to pass it to Kirk to introduce the issue.
Thank you very much. So I'm going to start at the very beginning, really, with just a quick summary of what is recreational immunity, just in case there's anyone out there that is only vaguely familiar with the idea. And what it is the legislature passed a statute a while back that basically said, we want Oregon landowners, public and private, to open their land for recreation in Oregon. And this was something that allows hunters to go onto land, hikers, allows people to access the beach, access our rivers and lakes. And the landowner whom opens that land, in exchange for opening it, they don't have to worry about liability, or at least they didn't used to. And that was called recreational immunity. So someone opens land for recreation, and in exchange, they don't have to worry about liability. And an immunity means that they don't have to fight the lawsuit at all. It ends right at the beginning. They don't have to pay an attorney all the way through trial and hope for a victory. It just stops it in its tracks right at the front. That's what's nice about an immunity. And so recreational immunity provided that to landowners who opened their land. So what's all the hubbub? What happened here? The case that changed things this time, there have been cases that changed things in the past repeatedly, and our legislature has kind of undone the court ruling and restored recreational immunity multiple times previously. That may happen again here, but right now, there was a case called Fields versus Newport, City of Newport, out on the coast. And what happened there is a woman, Fields, and her friend were, they would walk their dogs out through a improved path trail that the city of Newport owned, and it had some improvements, little bridge over some wetland areas. And they would walk their dogs along the beach and socialize. They were very open about this, this is what they were doing. They'd do it 2-3 times a week. And then one time they're coming back from the beach and going over this path, going over the bridge, which had gotten wet and slippery. And the woman Fields slipped on the bridge and broke her leg. She then sued, claiming that the city was negligent in maintaining that bridge, and there should have been warning signs up about how slippery the bridge was. So she sued, and the trial court said, hey, land was open for recreation without a fee, and they observed that walking your dog and socializing with a friend is recreational, just as a matter of fact. And so recreational immunity applied, case over. Fields appealed that, and said, and this is the new part in this case that we haven't seen before. Fields argued that in my mind, my primary intent, which is language from the statute, my primary intent in my mind was not recreation, it was accessing the beach. I was walking, but I was walking with my dog to access the recreational area. I wasn't recreating in the time. That was not my intent. And the law does say what the primary intent of the person is matters, their principal purpose. So that was a new twist. And the Court of Appeals agreed with her and said, if in her head, her primary purpose was not recreation, but in accessing the beach, then she does not get immunity now, but has to, the city doesn't get immunity now. The city has to pay attorneys to go all the way through trial and prove to a jury, and the jury must agree that in her head, her primary purpose was recreation. So there's this fighting about what someone is thinking in their mind, basically as a way of making an end run around the obvious facts, at least to me, that walking with your dog and friends and socializing is recreational. But that's what changed in this case. So recreational immunity doesn't stop a case at the beginning anymore. It's not an immunity from suit. It's more of a defense that you can bring up at the end of trial. And what's so troubling about this is that there was this initial bargain that the legislature put into place that said, hey, if you open your land for recreational purposes, you get recreational immunity. You don't have to worry about paying for defense costs in litigating cases of people who get injured themselves on your property. So there's this incentive to open property. And now property is largely still open, but the incentive that was part of that bargain, immunity, was taken away by the court. So naturally, anyone who likes to use paths, trails, recreate in Oregon on private property or public property, and wants those to stay open, wants recreational immunity to continue, and then landowners as well. So, landowners now have a decision to make where the bargain has changed. They're not getting what they were promised when they decided to open their property for recreational purposes. So what kind of needs to happen is to make it clear that a trial court can decide at the beginning of the case whether or not a plaintiff's primary purpose in entering land was recreational or not recreational based on their outward actions, the facts as you see them, and get away from this subjective intent in their head, which will be whatever their attorney, well, I shouldn't go there. See, whatever their attorney says it's going to be. I'm an attorney, so I don't mean ill will on attorneys with that. It's just how it seems to play out. So really focusing on objective activities at the time is where we want to see this go from here. The good news, as I mentioned earlier at the beginning, is that the Oregon legislature has repeatedly stood behind Oregon's policy of encouraging private and public landowners to open their property for recreational activities like hiking, mountain biking, kayaking, hunting, fishing, rock climbing, accessing our beautiful coastline, all those things. And we, or I, hope that that will happen again and that the bargain will be restored once more. But But in the meantime, what this really means is that the bargain has changed, and you have to evaluate, whether it's worth the risk of opening property or not. Now, there are some things that can be done. In my professional role, I'm advising cities and counties, but my advice wouldn't change if I were advising a private landowner. If you want to keep the land open, it wouldn't hurt to put up some signs that say, if you agree to go onto this land, you are agreeing that your purpose is recreational. And if you don't agree, turn around and walk away, or something to that effect. The plaintiffs in this case would probably say, what you really need to do is increase maintenance and put up warning signs, slippery when wet. And those things wouldn't hurt either, of course. Those are all good. But none of those changes the bargain that we would like to see restored. So that's kind of the initial overview, I think. And I'll pass it back to Steph, unless we're taking questions along the way.
Yeah, thank you, Kirk. And I forgot to announce at the beginning of the webinar that we invite folks to submit questions using the Q&A feature at any time. I'll also do my best to keep an eye on the chat, but it'll be easiest to see your questions using the Q&A feature. And we'll have some Q&A where we can invite all of our panelists to respond after our initial introductions. One potentially just clarifying question, though, that I'll shoot to you now, Kirk, is if there's a standard definition of improved trail in this context when we refer to improved trails.
So it would basically be, a trail that's worn through grass. If you picture that, that wouldn't be an improved trail. An improved trail would have handrails, steps, bridges, boardwalks, or anything more. So something that's built would be an improved trail, built improvements.
Thank you. Next, we're going to go to our two public agency partners who are with us on today's webinar. We're going to start with Chris Havel at Oregon State Parks to just give us an overview of how Oregon State Parks is looking at and responding to this issue right now.
Hi, Steph. Thank you. And thank you in general for bringing us all together. Clearly a lot of interest and looking forward to great questions, even if there aren't great answers yet. So for the Oregon State Park System managed by the Oregon Parks and Recreation Department, we became aware after it went through trial and after it went through appeal, and even as it was appealed to the Supreme Court, who declined to hear the case, that it's possible that through this action that the recreation immunity landscape might be changing. And we're watching that very closely because our public service, the way we interact with state park visitors, the way we program our maintenance, and the way we fund development of the park, it's evolved in the context of the recreational immunity statute and the limited liability protections that it provides. But we also don't know what those changes are yet. So we haven't closed any facilities. We're not planning to just for this reason. Things do close and open all the time because of conditions on the ground. Even this last series of winter storms has prompted closures while we do trail clearing and check facilities for damage. But in the short term, we're not making any changes. We want to see how it shakes out. And this month will be an important start to that as it goes back for the first set of hearings in court. I think middle of this month. We have gotten together with Department of Justice and the other state agencies that might be affected by a change in the way that this law is applied. And we're going to continue doing that not just as this works its way through the legal system, as is the right of everybody involved to let justice follow the path that it's going to follow. We may have to make changes. If we do, we'll adapt to those. We're also going to sort of take a longer term look to see if there are other longer term changes that we might need to make to the way that we operate. So it's sort of that wait and see mode. We don't want to be too hasty, but concerned that there might be changes that require us to adapt quickly to anything that happens at the court level.
Thank you, Chris. And next I'll invite MG to talk about how Metro Parks and Nature is looking at the issue, and also what you're hearing from other local agencies in your region.
Thanks, Steph. Good afternoon, everybody. My name is MG Devereux, and I work for Metro Parks and Nature. Metro is the only regionally elected government in the country and oversees what we now know as a region in Multnomah, Washington, and Clackamas County. And we manage about 18,000 acres of parks and nature land. A little bit different than state parks in the type of facilities that we manage, as our primary mission is really centered around habitat conservation and water quality conservation, but also looking at ways that we connect people to that natural opportunity. And like state parks, we're very much interested in how this decision changes some of the context of how we do recreational development, how we do some of our management practices, and where we're really looking at opportunities to think about the way that we deliver service. When the decision came out and we heard about, sort of various opportunities to either think about closures or ways to look at trails, we also made the decision not to close trails, really based on sort of two overriding principles. The first of those principles is really a commitment to safety that underlies a lot of our work. We've got tremendous operations staff and recreation planners that are really focused on thinking about how we do trail design, how we do everyday maintenance in a way that really identifies where some of those risk points are. I think one of the challenging pieces of this conversation, as many of us in the audience know, is you step outside and the outdoors has some inherent risk into it. And so how to approach a situation where you might think about putting a sign on everything or signing a waiver becomes really difficult to sort of wander all the way through the what ifs and the possibilities, which was one of the reasons that, as Kirk said, there was a sort of an assumption behind how the rules of the game worked that has been sort of challenging to approach this discussion. Metro also has a number of grant opportunities that we manage. One of our roles in the region is coordination with the 27 park and recreation districts or providers here in the area. And so we provide money through grants, through bond funds to help people develop those recreational opportunities and access points to nature. And some of those have a multitude of underlying purposes. Many of you may know Robert Spurlock, who helps with our regional trail program. And so we're looking at ways that we develop multimodal trail opportunities that connect different places across the urban area. And those can definitely be for recreation, but they can also be for other purposes. So when thinking about how we approach a conversation that has sort of changed the rules of the game, it also becomes very challenging when we start thinking about where some of those solutions and long-term options might be. One of the things that we also do a lot is work with our other partners. One of the other organizations that's been doing a lot of work on this is the Oregon Recreation and Parks Association, who's been actively involved in the topic of recreational immunity for a long period of time. And if you're not a member, I'll give you a little pitch for a good organization that brings a lot of good people together around these conversations. what we've been hearing in those conversations with ORPA and with the regional providers is just a lot of confusion. And I think we're seeing some of those same questions that we've been talking about in the chat in terms of, will a sign work? Is it enough to have your local jurisdiction, sort of say this area is for the purpose of recreation? And that's one of the other reasons that we've decided not to approach a closure preemptively, is that the core mission of Metro Parks and Nature is to provide the opportunities for habitat protection and connection with nature. And so preemptively closing really undercuts that mission and really the role and the public service that Metro Parks and Nature seeks to provide in this space, which I'm sure many of you, as I see some of you in the audience, are in those same places. As we move forward, and I think some of this discussion really is, how do we take this conversation over a very specific change that's coming at us quickly, and not keep it sort of in a siloed conversation. And so great thanks to Steph and the Trails Coalition for bringing this together to really talk about different ways that we can approach and share our different perspectives. One of the things that I also just sort of want to make a note of on that safety point is that recreational immunity is one part of the conversation. And I think it's very important for us to talk about it because this is a change, but also a recognition that discretionary immunity and other ways that you manage your system or your trails are equally as important. And so making sure that you've got good maintenance practices and you've got good communication practices with your staff and with your visitors is a part of a holistic solution towards sort of resolving how we think about managing the risks that are on our landscape. Last thing I'll say is maybe this is also a time to have that bigger conversation, not just about recreational immunity, but also most of the park providers in and around the state will say resources are tight. And so how do we have the opportunity to talk with the public, with our elected officials, with our stakeholders about how we approach funding for trails, for recreational facilities that really expresses the needs that we have in the areas of development and maintenance and operation.
Thank you, MG. You're really speaking the Oregon Trails Coalition language there. We're very interested in, both protecting access to our trails, but also increasing the resources for our land managers to maintain and manage and develop them. So near and dear to our heart. We've got lots of great questions for our panelists coming in already, but and some of the questions relate to, management practices in the context of the current law. But before we kind of dig more into the details around all of this, I wanted to introduce our last panelist, Erik Kancler, to give a view of what are the conversations, what are the fixes that folks are looking to the recreational immunity law. What are folks talking about in terms of legislation, and who else are you hearing from who cares about this issue?
Great, thanks, Steph. So my name is Erik Kancler, and I am a public interest lobbyist who's spent quite a number of years working in the outdoor recreation space, and I'm working with the Oregon Trails Coalition and a number of other interests in the legislative process right now to seek solutions. So what we have in front of us right now, most folks probably know Oregon has a 2-year legislative cycle, a biennial cycle that tracks with a 2-year budget. And in odd years, we have 5-month sessions. And in even years, we have 5-week sessions. So we are now just shy of a week short of the 2024 short session. Starts on February 5th. It's constitutionally required to be done by March 10th. So it's a limited amount of time, and it's going to be a packed session. In terms of this issue, these issues, recreational immunity in particular, it's probably unrealistic to think that a short session is going to yield a comprehensive solution. And frankly, we're not really looking at it this session. There's a lot of bigger picture concerns, longer standing concerns, coastal access and other things that are going to have to wait for the long session. But for the short session, really what the conversation has been about with advocates and legislative members and others is, in light of the Fields versus Newport case and all of the concern about increased and unexpected liability, the point is, well, what can we do right now, kind of as a Band-Aid, as a, cover things that are unexpected liabilities as a result of that. And so we are looking in the short term at really two things that you've heard already. One, trying to key off the intention of the landowner. If someone is making their land available free to the public for the purpose of recreation, then that's what matters in terms of if somebody is going to use it, whether they're protected or not, or whether immunity applies. So another way of putting it, it wouldn't be up to the user to say whether they were recreating in their own minds or not. The purpose is recreation. That's what matters. That's how people have been operating for a long time. So that in a general sense, we're hoping would be restored, as well as you've heard before, the difference between immunity protection between improved and unimproved trails. What we now are seeing as a result of the summer court case is a lack of immunity protections for improved trails. And so that's really the second policy level component, is restoring a level of protection for the improved trails, hopefully to match those on unimproved trails. So there's been a lot of conversation for maybe the past 4, 5, 6 weeks, maybe a little bit longer, at least in the inner circles. And where we think the action is right now is in the Senate Judiciary Committee. The Senator Floyd Przonski out of Eugene held a informational session prior to the start of session in which this topic was raised. And so there's a lot of conversation about whether or not we could find a compromise with the trial lawyers, who by and large are our opposition on this case. I think it's too early to know what's going to happen, whether we can find some sort of compromise or some sort of agreement. And that's going to be very apparent over the next couple of weeks. Now, Steph, you mentioned who is working on it from our side, and it really is a broader array of interest. You have public land providers, cities, counties, parks, special districts, state parks. You've got private providers, including a variety of small woodlot owners, larger forest owners, land trusts. You've got a wide variety of recreation. It's really any recreational mode that you can think of. We probably have representation and participation. There's quite a few environmental groups. Environmental stewardship is very interested in this, and then a variety of broader outdoor recreation and public interests. So I'll leave it there, Steph. I know you've got another set of questions or topics you'd like me to cover, but I'll kick it back to you for the moment.
Yeah, well, I wanted to kick it back to Erik for a moment, and then if others have content to add on this as well. But some folks are aware of efforts around recreational liability last legislative session. So I wanted to take a moment to clarify how recreational immunity is different and or related to the recreational liability issue as it relates to waivers, and whether or not partners are trying to address that at the same time or through the same legislative vehicle.
Great. Okay. Thank you. So Kirk went into this in some detail before, liability versus immunity. Liability has to do with waivers. If you sign a waiver, does it matter? In most other states, and I think almost entirely across the board, with minor exception in the Western states, if you go to a ski resort and, for example, or you're doing river guiding or something like that, you sign a release of liability that has certain terms in it. that really specify what the user is liable for legally if something were to occur versus what the provider landowner is liable for as well. The unfortunate reality due to a 2014 ski case is that in Oregon, the content of the liability waivers really doesn't matter in the sense that it may say that the provider is protected for certain things, but in actuality, that legal protection doesn't really exist as a result of case law in Oregon. So liability is mostly associated, but not entirely, with paid recreation and the signer of a waiver. Again, immunity involves, there's no paperwork involved. It's upfront. If land is being made available to the public free of charge for recreation, there's a presumption of immunity based on statute and case law. And as you've heard, that has also been eroded mostly through in Oregon through the court system. So what are we working on this session? Well, stepping back for a moment to last session in 2023, there was a bill, Senate Bill 754, that focused on the liability, the waiver side of things. That received quite a bit of attention. It did receive a public hearing. It did not advance out of Senate Judiciary. And so there is definitely some unfinished business there of great importance to outdoor recreation. That's not on the table for the short session. And of course, there's larger issues around immunity as well. So we're seeking a smaller fix relevant to the Fields versus Newport decision in the short session. But there are, as I mentioned, and others have mentioned, there are a lot of other elements to the immunity conversation, a lot of other vulnerabilities that have turned up over the years. So I really think that it's critical for outdoor recreation that both of those get an emergency fix now on immunity. We take a really concerted and probably joint effort on immunity and liability for the long session. Many of us see those as two sides of the same coin that under different circumstances offer critical legal protections for those that are providing recreation opportunities to Oregonians. None of them absolve the providers or the landowners from liability for gross negligence, for example, or, really what we're talking about is a balance of personal responsibility. Some of it's going to fall on the user, some of it's going to fall on the provider. Right now, the courts have really put a lot of it and an unbearable amount on the provider, and we're seeking, in the long term, a better balance.
Did any of our other panelists want to kind of bring in on that distinction between the immunity issue and waiver and liability issue before we move on to our other questions? Okay. Well, we have both had a lot of great questions in our Q&A today, and some questions that I've brought that have come into the Oregon Trails Coalition before today's webinar as well. And I wanted to start by going back to our land managers, because one question that I have gotten has been kind of around, well, is this reduction in recreational immunity good in that it will cause land managers to either close trails that should be closed for safety hazards, or will cause land managers to do maintenance they should do. So I just wanted to ask for some context about what kind of protocols are already in place for agencies to decide when to close a trail or when major maintenance is needed, and just kind of give that some context.
Yeah, so Chris, State Parks here. Managing a park is an art. There is no yardstick that says, oh, nope, this one is it's met the trigger and we must close. You're always engaged in this conversation with yourself and with your peers in a park and at other parks around you to say, yeah, what should I do here? Erik, you mentioned that parks are in many ways a conversation between managers and visitors to try and figure out who ought to be doing what. So we do hazard tree assessments where we say, yeah, a tree or a significant limb is not just in danger of coming down, but that there's a target for it, either a place where people congregate or a significant trail or a facility or a parking lot. And we attend to those. Outside of those target areas, not so much. People like parks because they're not groomed. They're not a wholly maintained landscape. That's part of the beauty that people are after when they visit. Whether you think of beauty as a recreational activity, I'll leave that to you. So you're always in that dance, and it's the same for trails and other facilities. You see a handrail, a tree fell on it. You make the judgment: is that something I need to close the trail to fix, or can I keep the trail in service while I fix it? There's no hard and fast answers there, but our system and sort of the sensibilities that our staff have they've evolved along with the limited liability protections provided in the recreational immunity statute. So if something disturbs that balance, then you have to go back and you look at it again. We're in the business to provide experiences for people that they find valuable, but we know there are thousands of inherent risks in engaging in outdoor recreation. There are people who are new to recreation, and then you have that conversation. How much do I need to let people know about before they visit? How much do we simply need to encourage people to be prepared before they visit without getting into a laundry list of all of the things that could happen to you when you're out playing? We'd want to list all of the wonderful things that can happen, and then we'd have to list all of the things that might cause you injury or distress. And that becomes very quickly difficult to manage. And you end up just having this constant relationship with people to encourage them to be prepared, know your limits. If you're not sure, ask somebody who is more sure than you are before you visit, and you count on that so that we can keep parks natural and people can get the experience that they want. So yeah, there are protocols in place for closing things, for inspecting them. We have schedules for different kinds of facilities, but in the end, in spite of all of those metrics, and I love using that word, it's an art. MG, you have anything you want to add to that?
As always, well said, Chris. I again would give a really good plug for the providers to think about how they've created those processes and those protocols. I personally am a big fan of the Safety 2.0 movement, a plug for an author, Tom Coughlin, and 5 Principles of Human Behavior, which really talks about how to approach risk mitigation. There's a lot of questions in the chat about, well, would the sign say this or could the sign say that? And Chris and Erik and I have had conversations about how long the sign could be, and then there's the question of where should the sign be. You can't have a sign every 10 feet. You can't have a staff person every 4 foot. You can't have a guide for everybody to come through. And so that conversation is really important, and it is a conversation with the park user, but it's also a conversation with your organizations to make sure that your folks have the good understanding of where the limits of that art are and on what conditions closure is possible, and then how you communicate those risks and those ameliorations in and around. That's a critical step for having the processes in place to make good decisions. That somebody will challenge your decision. That is part of the art. And I think getting back to what Kirk said about that agreement, part of our quest here is to have the rules of the road and the agreement sort of understood and to be within side of our control, because understanding what is going through somebody's mind when they come to a park and may be there to use a trail or use a restroom or walking from one side to the other to get to another location. Those are things that are really very difficult to plan for from a design, a maintenance, or an operation perspective.
Thanks, Chris and MG. Kirk, while I know it's at the heart of your job to advise cities and counties, I'm hoping you can help us with some of our questions about kind of other land contexts and when our current recreational immunity law applies or not. So I'll have a few of these questions in the pocket, but the first is, are there differences in how recreational immunity applies to federal lands and trails on federal lands in Oregon?
So that's a good question. I don't think it would apply at all. I think the case against the federal government on federal land is going to be in federal court, and they're going to say they're immune from everything. And because they make the rules, it's really hard to, good luck with anyone who wants to sue the feds. So yeah. I don't think any federal landowners here. I doubt the feds close anything because of this rule, because they just do their own thing.
All right, next question for does it count? I feel like I want a game show buzzer or something for this portion. How about if there is a parking fee for a park site, is that still considered free to the public access? Kind of how does that interface with recreational immunity issues?
Yeah, I've gotten that question a lot in the past. There was some litigation previously around fees. You know, if you're paying a parking fee or a reservation fee for, let's say, a gazebo in a park because you want to have a birthday party or a wedding. And generally the rule is if it's possible to show up and use the property for free, like you could walk there, you could not reserve the gazebo and just show up, then recreational immunity will still apply. That you can charge for parking, for reservations, for lighting at night. Now, keep in mind that every time you add a fee, you're reducing the likelihood that recreational immunity will apply. So I would say be cautious about those things and modest in what you charge. The one piece that is has to be specifically addressed with fees is like camping. So if you have a campground that has overnight camping and a bunch of recreational areas, there was a case about someone who came and paid for a campsite, then they were off in a place that's generally open to the public and crashed their mountain bike and said, oh, recreational immunity doesn't apply because I paid a fee for my campsite. And now there needs to be a statement on their payment for the site that says recreational immunity still applies to everywhere else. So that's the one thing with fees that's got to be addressed. But parking, short answer, you're fine.
All right, and then another kind of related question on what about private lands where folks encourage a donation? If there is are invited to recreate on private lands with a donation. And I've certainly, this might apply to some land trusts. I've seen it at managed like cross-country ski areas, for instance.
So I don't advise private landowners, but one of my standard answers is if it's possible to show up and use the land for free, recreational immunity should apply. So that's how I would answer that one, because it's not required. A donation is not a requirement. You could still show up if you can't afford a donation and use it for free. Recreational immunity should still apply, but maybe one of our other panelists would like to address that.
Anyone else have anything to add? I'm not seeing big enthusiasm to add to that answer on that. So we have lots of answers for you all today, but there might part of the issue, the current issue is the fuzziness of the law. So that's going to be part of our context too. Another question about when this applies to. So for instance, with as part of the Oregon Trails Coalition, we are really committed to, the investment in all types of trails, including trails that very clearly provide double service as recreational corridors, but also transportation corridors. So if a trail is, often used for transportation as well as recreation, does that change the recreational immunity landscape at all?
So in my opinion, those currently under the current case fields, especially if someone is using a trail for transportation, their use, if they are injured, recreational immunity would not apply. Whereas right alongside them, someone, is traveling right next to them, two people biking, and one is biking to work and one is recreating, and they both crash from the same thing. The person who is going to work, recreational immunity would not apply to them and they could sue. The person who is recreating, recreational immunity would apply and they could not sue. It's one of the probably unintended consequences of this rule.
Thank you for that. And then there also is a question about kind of outside of trails. Does recreational immunity apply on other public facilities like roads, sidewalks, etc.?
So roads and sidewalks, typically not. There was a case that held for a little while that if you were recreating on a sidewalk, that it applied. It was a trial court ruling, and then that was overturned. So I generally think roads and sidewalks, no. It might be a case where it applied, like if the road is shut down for a recreational purpose that's open to the public, like for some kind of festival. And so it essentially becomes a park. You close down a block and it's open to the public, but closed to traffic. That might apply, but generally no.
Thanks. Now I've got a question for both Kirk and our land managers. And folks are looking for specific, I guess, more guidance and more thoughts around signage. So kind of in the current recreational immunity context, what are the best practices around signage? And both, are there places folks can look to for recommended verbiage for signs? And then also questions about, is there a best practice for where you put these signs? Because there could be so many hazards along the length of a trail. Is there common best practice folks can point to around signage, both in terms of verbiage and location of where they are best placed?
Yeah, I think MG mentioned a couple of criteria earlier on. In general, signs, in general, but not always, signs are reserved for areas where people congregate, where we know we can keep them up in good repair, and where they can present clear, concise information about whatever it is the subject of that sign is. In the case of risk, you see them most often on the coast, where it's things like danger, stay back of cliffs, know the tides. On trails in other areas, you tend to see them mainly at trailheads, where you'll see an admonition to stay on the trail, and here's why. Those do tend to be more rare. just because you know that, especially for trails of any length, sometimes those warnings just don't stick very well, and you're just trying to raise awareness. But you don't want to take the experience that you're trying to provide and that people are after and turn it into a billboard or a walking brochure or something like that. So setting aside interpretive signs and those sorts of things, just sort of the advisory warnings, you look for where people congregate and where you think you can get the message across quickly. MG did mention discretionary immunity as an option. That refers to a policy decision made at a very high level in your organization, usually your governing body, where you are intentionally managing some risks, but not others, and you explain why. And that can free you up from having to just plaster the entire landscape with signs, but it takes a lot of work to develop that and to make it viable if you were challenged in court.
Anyone else have anything on sign best practices?
I
I
would,
will, go ahead.
I would say one thing about signage. You know, it's something that you can do to reduce risk a little bit, but it's not, some of the questions have said, would this work? Is this a fix? You know, no, it's not a fix. And it won't, it's not like it will put recreational immunity back in place. You know, it won't. Trying to stop lawsuits with warning signs at trails is kind of like trying to stop water with a net. You might block a little, but it's not going to catch it all. So it's something you can do if you're going to keep trails open, but don't plan on it working 100%. It's a Band-Aid.
We have another question about how Oregon's recreational immunity law compares to neighboring states, particularly Washington and California. Anyone? I did learn the fun fact that all 50 US states have some kind of recreational liability protections in place. So, but I can't tell you too much about the details of comparisons between states.
I know that Washington has a much clearer, stronger set of regulations around recreational immunity. On the liability side, pretty much all Western states have much stronger laws than Oregon. I don't have a comprehensive set of how immunity varies from state to state at this point, but I wouldn't venture to say that Oregon's laws are relatively strong on immunity. I think they're quite weak when you talk to people who do have a national context.
Yeah, you do have a person here from Washington. Brody could maybe post a link in the chat for everybody to refer to.
We also had some kind of additional questions about, you know, what makes an improved trail, or kind of what makes for something that is built or has structures. So, you know, a trail cut into a slope, but with no handrails or stairs, I would assume, you know, anything like that. Would that be considered an improved trail?
I'll go out on a limb and say I don't think so. I think that would be an unimproved trail. But you got to know that an attorney on the other side is going to argue with me on that.
Let's see. I am scanning through other questions to see if we have other questions that we haven't touched to or answered yet in our final moments here. I think one thing that a couple of folks have mentioned that we haven't really explained in this webinar is discretionary immunity. And so I'm wondering if we could just give a little bit, maybe more context about how recreational immunity and discretionary immunity play together, how they operate together.
I can take a crack at a quick description. Discretionary immunity, imagine, I usually am advising cities and counties. So imagine a city council votes to spend the last bit of their budget on a stoplight instead of a guardrail in another part of town. Someone then dies because there's not a guardrail keeping their car on a road, and they sue saying, you voted for the wrong project. You know, you made the wrong decision. And discretionary immunity says, you know, you can't sue government for making the wrong decision on a judgment call. And that's really what discretionary immunity is. And because imagine, I mean, enough of life is tied up in litigation now. If every decision by a government could be litigated, you know, nothing would ever happen. And that's the intent of discretionary immunity. So in cases like this, if someone argues that a blacktop on a playground should have been redone at a school earlier because there was buckling in it and some kid tripped and hurt themselves, if the school could show, hey, we have a plan to go around a school district, all of our different locations, and fix this, and this particular school is lower on the list and we haven't gotten to them yet, then discretionary immunity would apply and they could not be sued. So you can't be sued for making the wrong decision on a judgment call.
Well, we have lots of very specific questions in the chat that we're unfortunately not going to get to today. But I did want to address one question broadly in terms of why this issue is so important to the Oregon Trails Coalition, that Jennifer Wild put in the chat of what are the implications for access for people with disabilities if developed trails are under additional scrutiny and land managers are hesitant to build infrastructure that would improve accessibility. And to me, this is really the heart of the issue for Oregon Trails Coalition. Is it is so important to us that we see a fix to Oregon's recreational immunity law that clearly provides protections for public and private land managers that open their lands to the public free of charge, and that clearly applies to both improved and unimproved trails, because we don't want there to be any disincentive for investing in trail infrastructure, for maintaining it, for managing it, for developing new trails that people are looking for in their communities for a huge variety of trail activities. And that's also why it's very important to us that this law continues to create, you know, incentive for investing both in you know, natural surface trails as well as those paved trails in our communities that do double duty as recreation and transportation corridors. So as far as some next steps from today's webinar, we will share this webinar link in our blog once we're able to process the recording and everything. That might take a couple days to get the video trimmed and everything, but we'll have it up there. And we'll share some additional links to other resources on this issue. CIS has some good FAQs online, city county insurance services. So we can share links to some of those additional resources that have already been provided for partners out there. I'm also going to share a link in the chat now for the Protect Oregon Recreation Coalition, which is a coalition that we're a part of that it has concerns about both the recreational immunity and recreational liability landscape. Currently, we're very focused on recreational immunity, and we invite folks who also want to see this issue addressed to sign up there as part of that coalition. And also invite everyone to join us for our Oregon Trails, our Trails Day in the Oregon Capitol, where we'll be sharing not just our concern for addressing the recreational immunity issue, but also sharing our love of trails with our legislators and why it's so important to invest in them, along with restore kind of protections for public access to them. This recording will be available for whatever purpose people choose to use it for. Is for the question for that. So we'll make it available on the Oregon Trails Coalition blog. Thanks again so much to our panelists for sharing some of your time. I know there are some additional questions we did not get to in detail today, but hopefully we were able to address some common understanding of the lay of the land. So deep gratitude to everyone, and deep gratitude to everyone who tuned in today to learn more, and especially all of you who are engaged in maintaining trails or providing programming to make those trails friendly and welcoming to our communities, and you know, touching this issue in all the different ways, and the good work you do. Really appreciate you too. Thanks.